Okay, welcome everybody. Let's get started on today's free webinar, Digital Accessibility, the Law and You. Now, it's going to flick back the screen to do our welcome. So thank you everybody for joining us. Whilst this is a virtual gathering, I would like to start by acknowledging the traditional owners of the land on which we are separately meeting today and pay our respects to the elders past, present and emerging. Before we get started, a few housekeeping rules. Most of you should be muted and have your video off automatically, but if for some reason that hasn't happened, please turn off your video and your microphone just so it saves on background noise and a little bit of bandwidth. We were hoping to have captions today, but that unfortunately has fallen over for us once again, which is not ideal, but the video will be recorded. We will pop it on our YouTube channel with captions and with a transcript, and that should be up early next week. If you have any questions for the panelists around the content of today's webinar, please pop them in the Q&A box. And as we go, we will go through your questions at the end. And if you have any questions relating to the technical side of things or any other comments you would like to make, you can feel free to chat in the chat box as well. I'll be watching the clock and trying to keep us on schedule and on time as best as possible. And hopefully we'll allow quite a bit of time for questions at the end, because I'm sure that a lot of people do have questions about this topic. So moving forward, for those of you who are joining us for the first time, which is apparently quite a lot of you, my name is Charlie Parker. I'm a digital accessibility consultant with Digital Access at Vision Australia. As the name suggests, we are the digital accessibility consultancy working from within Vision Australia. For today's webinar, we have two guest panelists, Digital Access's own Matt Putland and Laura Cottam from the Australian Centre for Disability Law. Matt is a passionate accessible HTML and semantics expert based in Perth, has over 5 years experience with digital accessibility as his core focus, is a digital accessibility consultant at Vision Australia and works with clients to offer technical and remediation advice. And he also runs our WAT training course as well. Laura is a solicitor at the Australian Centre for Disability Law, where she provides advice and representation in disability discrimination law. And she's also worked in discrimination and employment law for over a decade at other community legal centres, trade unions, and in the corporate sector. So welcome to Matt and Laura. So today we're going to go through a few talking points around the subject of digital accessibility in the law. This information should by no means be taken as formal legal advice though. So if you do require legal advice regarding any specific situation, we suggest that you seek independent legal advice. We will be posting the contact details for the Australian Centre for Disability Law at the end of the presentation. So if anybody would like to get in contact with them. So I'm going to kick off the discussion with a question by asking Laura, what is disability discrimination?
Nice, broad topic. So, I mean, disability discrimination under the law, you've got to have established three things. So you've got to establish that you have a disability that's covered under the law. We've got state and federal laws. I know we've got people from all over Australia. So we've got a Federal Disability Discrimination Act, and we've also got individual state laws. The definition of disability within that is quite broad, so most things are covered. It includes temporary disabilities, includes future, and includes imputed disabilities. You've then got to be treated less favourably because of your disability. That can be what we call either direct discrimination, where you're not allowed to do something or you're excluded from something specifically because of your disability. Example, you can't go on that excursion because you're in a wheelchair. Direct, quite straightforward. Or we've got what we call indirect discrimination, where as a term or condition, it seems reasonable on its face, it seems neutral, seems that it's applying to everybody, but because of your disability, you can't meet that term or condition. You require what's called a reasonable adjustment, so something to be changed, to modify, so that you can actually access it in the same way as everyone else can. And if that adjustment is refused, that could be what we call indirect discrimination. And then, so you've got to have a disability, you've got to either be treated less favourably because of your disability, so there's got to be a causal connection, and then it's got to be in a protected area of public life. The main ones we look at are education, employment, provision of goods, services and facilities, access to premises, accommodation, and certain Commonwealth and government programs. So those are the kind of three things you've got to establish to be successful in disability discrimination complaint. But it's basically been treated differently because of your disability, and that can sort of play out in quite a few different ways. Oh, Charlie, you're muted.
Muted. Sorry, I'm trying to cut down on the noises of my dog snoring in the background while other people are speaking. So lawsuits and digital accessibility go hand in hand in any conversation. For as long as I've been in the industry, it's almost always the top reason given for people wanting to achieve compliance, or a selling point for people selling the idea of digital accessibility. But should that be the driving force? So we're going to do our second poll now, and this is on your personal opinion. What do you think should be the driver for a digital accessibility journey? So this is your own feelings. We'll launch the poll now and we'll give people time to vote. Hi to everybody else that joined us. We have 122 people in now. And currently we're sitting at 100% of it's the right thing to do. We've got a few on the other and a few also on the litigation possibility. So I'll leave it up for about a minute and let everybody have a go at answering that. And hopefully at the end, we'll get to discuss some of the other reasons as well that people think that it's important. So when we talk about lawsuits relating to digital accessibility, people often use the US as a reference point. And there's a few reasons for that. They have big numbers, impressively big numbers when it comes to cases being brought in relation to digital access. So in 2016, they had 262 cases. By 2017, there was 814. By 2018, there was 2,314. And by 2019, similar 2,235. In 2018, on average, there was a case being brought against an organisation about 1 every hour. So there was initially in 2020 a drop in those numbers and a little bit of relief, but the main reason about that was because of COVID, because everything was shut down, courts weren't open, lawyers weren't open, no one was able to litigate. Now things have opened up again. 2020 is about on track to exceed 2018-19 in the number of cases being brought. Yet in Australia, we've only really had 3 landmark cases. So I'm going to end the polling now before we move on. So we have 90% of people who are saying that digital accessibility is the right thing to do, 5% threat of legal action, and 5% of other. So in Australia, we've had 3 cases. Bruce Maguire versus SOCOG, so that was the Sydney Olympic Games Committee. Giselle Minaj versus Coles in 2014, and Nadia Matiazzo, and I apologise to Nadia and any of her friends and acquaintances who might be listening if I've completely mucked up how to say her surname, versus the Commonwealth Bank. So out of all of the, comparison to the numbers of over 2,000 in the US to only 3 in Australia, and they're all considered landmark. So I'll pass again to you, Laura. Why would that be? Why don't we litigate with the same enthusiasm as the US? And what governs digital accessibility law in Australia?
So I would say, I think if you're looking at the US comparison, that's cases that have been filed. And in a similar way, like that's cases that have been filed under the Disabilities Act. So it could be for a range of disabilities, a range of different issues. It doesn't also talk about successful cases or how far they go. In terms of those 3 cases, there are more cases that have happened. These are just the big ones in this area. And I suppose the comparison for us is possibly in the way the process works. Here, you first lodge a complaint at the Human Rights Commission before you take it to court. And so comparably with the Human Rights Commission, I looked up some of their statistics, and 2017-18, they had about 2,000 complaints of alleged discrimination. And in the last financial year, they had about 2,300 cases. And so of those, 70% are resolved at a conciliation or resolved as through the commission process. So I think the number of complaints are probably similar. We just don't rush to court because of the expenses involved in that. And I think probably the size of our our country in that way. So that would be, I suppose, one of the differences. If you do take something to court, so for the example with Giselle and Coles and with Nadia and Commonwealth Bank. Both of those cases are landmark because they were filed in the federal court, but they were settled out of court. They didn't go through a court process. So we don't actually have guidance. We don't get a lot of federal court guidance because it's costly. And so we just don't get a lot of cases to be able to work out if something is actually strong enough to take all the way through. And so most of those cases do settle, which is a good outcome for the complainant, and usually in some way. But it means we just don't have that body of case law to develop and to refer back to when we're actually lodging other cases.
Awesome. So in Australia, we are under the Human Rights Commission, so we don't have any actual digital accessibility laws. We abide by the Human Rights Commission, the Disability Discrimination Act of 1992, the United Nations Convention on the Rights of People with Disabilities, and that was ratified by 140 countries in 2008, and Australia was one of them. The US was not. And I will post links to all of these later, so you can have a look at what laws we are bound by and the kind of legislation that we are bound by in Australia. So what happens when somebody makes a digital accessibility complaint in Australia? I'm going to pass over to you, Matt. I have your accessibility complaints process diagram here, if you want to walk us through that.
Excellent. So yeah, when accessibility complaint occurs, typically the first stop for the complainant is to go straight to the organization and say, hey, I've got an accessibility issue on your website. And generally what happens is that complaint is either ignored, or they say, oh yeah, you know, apologies for the construction work in the background if you can hear that. Yeah, typically it's ignored, or, oh yeah, we'll check it out. You know, we'll investigate it, and nothing really seems to happen. You don't really get a date on when it's going to be fixed, or any sort of indication on, you know, when or how it's going to be fixed. So then the complainant has the option to plead their case to the Australian Human Rights Commission, so they can pretty much share their complaint with the Australian Human Rights Commission, and then the Australian Human Rights Commission will bundle that complaint up and basically send it off to the organization again and go, hey, now it's not just some random person giving a complaint, it's, hey, this is Australian Human Rights Commission sending you the complaint and going, hey, you really got to pay attention to this, you're impacting on human rights. And then hopefully the organization will take it a bit more seriously at that point, and you know, actually make more of an effort to resolve the issue. But ultimately it's still up to the organization. The organization can go, nah, don't care, or they can just ignore it, or they can say, yeah, you know, we'll check it out, we'll fix it. And they send that reply back to the complainant, or the Australian Human Rights Commission sends that back to the complainant, and then it's up to the complainant to actually decide if that response is satisfactory or not. So literally, is no response satisfactory? Is, nah, I'm not going to fix it. Is that satisfactory? That's basically still up to the complainant to do the next action, which go to a lawsuit or just deal with it. It's basically their two main options, or just keep complaining until hopefully something happens. So that's basically how the complaints process works. It's very much fully triggered and sort of organized, and the response is all from the complainant. There isn't really a body that can enforce an organization to make something accessible.
So is the complaints process prohibitive to people who find barriers accessing online content? So cost-wise, whether it's financial cost-wise, personal, family relationships. Matt and Laura, I'll ask you both to jump in on this one with your opinions. Do you think that the process is prohibitive, and you know, could it be done differently?
I might just start. I might add to your complaint diagram, Matt. So if the organisation does respond and they're willing, and again, they're not compelled to do so, they can participate in what's called a conciliation. So the commission does try to get the parties together to discuss what happened and how they can fix it. And that can form the basis of a binding deed, which if it's breached, you can then sue against in court. It's not always, and exactly that you're right, they could just ignore it and not do anything. But a lot of big companies particularly come to the table and go, we should do something. We should at least pretend to be doing something and engaging in some way. Look, I suppose the initial complaints process itself It's costly. It's not prohibitive. It doesn't cost anything to put a complaint in, but it's exhausting and it's tiring. And if you're putting your complaint in, as you say, if you've, when we advise people, we say, go to the company first and see if you can get it fixed that way. And if you've already done that, and then you go through the commission again, and again, they ignore you, or you don't get what you want, or you've got to go through an argument about explaining it, it can be exhausting. And you're right. Look, it is all on the complainant to actually do that. There's not, there should be some sort of general auditing process rather than person who's having the problem having to try and argue for a solution. And I think that the issue is, if they've just ignored you, done nothing with the commission, then you've got to think, do I want to go to court? There's costs involved in that. It costs to lodge a complaint at court. It costs to get hearing. It costs for lawyers. And if you're not successful, you're probably going to have to pay the other side's legal costs. And I think that's a prohibitive thing here in particular. That can be very hefty. And even if you're only successful on one part of it, and you're unsuccessful on another part, you could be ordered to pay some of those costs.
I had someone with low vision once tell me, she was saying, if I had to complain about every accessibility issue that I find on a website, I would spend my whole life complaining. It's something that, is so common to find accessibility issues on the web that you really need to pick your battles as far as what you actually complain about and what is worth it to complain. And that's sadly how it is at the moment. It's people really need to pick their battles, and it's because it is, a very, very tiring and exhaustive process to go through, and it really shouldn't be.
I agree. So one question that is often asked: are Australian businesses at risk of being sued under American discrimination laws? So there are a lot of cases being brought in America, and there are particular lawyers and law firms who are crawling and trolling for cases to be brought because there's money involved in it. And the short answer, without having a lot of legal background myself, is yes. If you have an Australian business and you have an American subsidiary of that business, then you are potentially liable under American discrimination laws. So for precedence, a gentleman named John Mahoney, he raised a class action in a Pennsylvania district court against Flight Centre. So their American subsidiary called libertytravel.com. John is a screen reader user. He is a blind man. He is also a tester, from what I could find in my research. So he tests for these things, and he found that Liberty Travel was not accessible. So he raised or filed against Liberty Travel, which is part of Flight Centre in the US. The same for airlines flying into the US. If you work for an airline, or if you are an airline flying into the US, then you are liable under American law that your website must be compliant to the ADA. Same for shipping companies. And there have also been complaints brought against Australian retailers where they have a retail arm in the US and their website is compliant to the US, to Australia, or maybe not compliant to Australia, but again, our complaints process is different and we're not as litigious because it is a lot harder to bring a complaint. So they have had complaints brought against them. As far as I know, none have been taken to court at this stage, but they have had complaints raised against them where they've had to remediate what they do. So, and it's not just America. America is the one that, because they are so litigious, they are always in court, they're suing for everything. That's the one that everyone flags. But Canada also has very strong digital accessibility laws, and as does Europe and the UK. So anywhere that you have a website or a presence in another country, you are potentially, and it's not necessarily going to happen, but you are potentially liable under those laws. So, I have another poll as well. Let me do the next poll. And sorry for this quote, Laura. I hope you don't take offense. We'll do our second poll now. And this one is, what is your organization's driver towards creating an inclusive and accessible online experience? So again, same answers: threat of litigation and possible legal action, it's the right thing to do, or other. And we'll compare that to what we've seen as far as personal goes. So despite the number of lawsuits in the US, most are settled out of court. They're often seen as nuisance cases. So they're seen as clogging up the courts from dealing with real cases. They're just troublemakers who are all going out trying to, get money out of companies. It's not really seen as there is a group of people who are misrepresented, who are underrepresented, and who have difficulties in a lot of areas and can't actually access these services that they should be able to. It is actually their human right. It's not seen like that. They're seen as troublemakers. Why can't they just get somebody else to do things for them? Surely if you can't shop online, you can get your mum or your wife or your kids or somebody come and do it for you, which is a really almost infantizing way of looking at things. As an adult with a disability, you want to maintain your independence and dignity as much as everybody else. And a lot of disabilities, that option gets taken away from you. So you should have the choice of being able to do things independently if you're able. So if there is an option for a website to be accessible to you, that website should be able to do that. So over 90% of accessibility cases are resolved in favour of the plaintiff, with many being settled out of court. Now that 90%, we have seen the opposite percentage of that. So it depends, I guess, on what source you're looking at. But the cost to business. Now, a lot of time when we talk about digital accessibility, companies will come to us, ask us about an audit, how much it will cost to have their website audited or this new product that they're building audited. And then they get a quote. And in the scheme of things, in the scheme of the entire project that they are building, the money that they're putting in to create this actual website or this software product, it's actually a really small amount. But once they get it, they go, oh, budget's a bit tight. I'm not sure that we can do that. So cost of business of law cases or lawsuits being brought against them, Target in the US had to pay out $10 million in damages and legal fees to settle a class action lawsuit by the National Federation of the Blind. H&R Block, tax agents, $100,000 in civil penalties and damages. And Carnival Corp, which is the cruise line. I kept thinking boats before I couldn't get the right word out. Carnival Corp, $405,000 in damages and penalties. So an actual accessibility audit, putting in the effort and the work to build an accessible product, is a lot less than that. And we're not just looking at damages and penalties, you're also looking at retaining legal staff. And you want a gun legal team who are going to go in and fight for you. So they're not cheap either. So the overheads and costs, if something does get brought against you, it's a lot more than just putting in the effort and putting in the money at the start of a project or fixing up what you've already got. So how did we go with that second poll? Oh, I didn't launch it. I was talking too much. Let's give that a go. Okay, I'll let everybody do the poll now.
Is this the first poll?
No, this is the second one. So this is the organisational driver. The first one was your personal driver. And this is the organisation that you work for. So when we're looking at the cost of litigation, the costs of going out and defending yourself. And unfortunately, there is a lot of defense in defense of not making products accessible, which to me, I don't understand. The case against SOCOG, they had the opinion that why should we make something accessible for someone who can't see? Then everybody will want to do something and we'll have to make everything accessible. To me, that's not an argument. The Domino's pizza case in the States, it wasn't Australian Domino's, but again, the same thing. The lawyers argued, why should we have to? The case against Liberty Travel, they're saying, the laws don't specifically cover digital access or digital accessibility. It talks about places, so gyms and locations and physical locations. So again, we shouldn't have to fix things because there's no law to cover that. And it shouldn't really come down to doing it by law. You know, if the law says we don't have to do it, so we're not going to me doesn't seem like a very good argument. I'm not sure how Laura and Matt feel about whether they agree with that argument, but to me, I just don't see that saying, well, we're not going to do it because we don't have to, and if we make it accessible for somebody who, you know, can't see the website, then we have to do it for everybody and it's going to cost too much money. I'll just share the results of that last poll as well. So Matt and Laura, anything to add to that one?
I'll say that the poll results are a bit optimistic. Yeah, absolutely. There are some organizations that do it for the right thing to do, and they are the best clients that we work with. But there are plenty that are just worried about meeting WCAG as far as meeting the minimum level of conformance just to avoid any threat of litigation. Even though in Australia, it's pretty unlikely you're going to get sued over it. But that's still their main focus, is to just cover off on WCAG, tick that box.
Yeah.
That's what a lot of organizations focus on.
And that's where we have to start thinking and I guess pushing within your organization. How much could you actually potentially save by putting digital accessibility first? So what can we do better? How can we reduce the risk of litigation? You know, there are many companies arguing for discrimination, and even in America, the ADA, there is now a proposed Online Accessibility Act, which actually waters down the current ADA agreement and its powers. So this is a space to watch. So this is a bill that's meant to pass it, and in about the first paragraph, it actually seems like a really positive thing. But as you go further into this bill, you can see that the rights of people with disability are actually reduced by this new Online Accessibility Act that America are looking to introduce. So looking at what we can do better and how we can reduce risk of litigation. Matt and Laura, any ideas there?
I gotta start. For how we can do better, absolutely. If you go to any accessibility conference, the main thing that gets beaten into your head is think about accessibility far earlier in your project. Think about it during the planning and design phase, not just during UAT or after we can actually get in and look at the full website. Because at the end of the day, you need to, a lot of the core decisions around accessibility on your website or mobile app is decided during the design phase, during the planning phase, on how things are going to work, how things are going to look, and how things are sort of put together on the website. And fixing those, if you identify accessibility issues at those stages and fix them then, it's far easier and quicker and a lot cheaper to do it then than to try and do it later after everything's already put together and you need to have your developers working overtime to actually get everything as it should be, things that should have been designed well at the start, as it should be before you end up launching your website. That's where the real costs and time crunch comes from, is when you try to leave accessibility to the end. So I implore all the organizations here to think about accessibility earlier in the process, and you'll find that it's going to be a lot happier time with accessibility. It's not going to be as stressful.
Definitely something that comes up a lot. It's sort of when people think of accessibility, it's like something really tedious and really hard to do. I actually saw an article on LinkedIn that compared digital accessibility with cooking, and they talked about baking and baking blueberry muffins, but forgetting to put the blueberries in. They say it's a bad season, you want to make blueberry muffins, but blueberries are really expensive, so you decide not to put them in, and then you get your muffins out and you realize they're not blueberry muffins. So then you take your finger and you poke holes in your blueberry muffins and you put the blueberries in the muffin. You've got a blueberry muffin. It's not going to be the same as one where you actually added the blueberries as an ingredient and baked into the muffin. I like food analogy, so that one really sat well with me. You could do the same with the chocolate chip cookie, I guess, but it's that same idea. You know, if you build it in from the start, it will fit seamlessly and it'll become part of what you do. If you're trying to retrofit everything, you're going to end up with that car that Homer designed in The Simpsons, where it's a car but doesn't really quite work or look good. So the other thing that we're hearing a lot about is accessibility plugins, overlays, and widgets. Matt, is this something that organisations can use? You know, the people selling these overlays and these widgets are very confident that if you put this on your website, it adds an overlay and you will be compliant, not only with WCAG, but also with the ADA. Is that something that companies could potentially be looking at?
Yeah, so there are some tools out there where you can put it onto your website. It's basically an extension. You pay this organization a fee per year or per month to have this little plugin on your website. And the promise is that if you put this plugin on your website, then no matter how inaccessible your website is, it will now be accessible and people with disabilities can now use that website. It does help a little bit as far as adding some accessibility features to your website, but it doesn't actually make it WCAG conformant despite what those organizations say. There's a lot of things that the tool can't do as far as making your content accessible, as far as making things actually accessible. It gives the sort of kind of like a appeal or sort of like a view that, oh, we have this plugin, so, you know, surely our people with disabilities can get through our website now because it adds all these extra accessibility features, but really that's not what accessibility is about. As far as the tools out there, you know, they aren't going to be very, very accessible as far as actually making your website accessible for people with disabilities. So what was the other part of the question, Charlie, as far as the tools?
Will they make your website, so is using some of that, you know, putting an overlay on going to stop or at least reduce your risk of litigation?
Nah, anything like that, it doesn't.
I actually did some research, and in September in America, 20 companies in September alone actually had cases brought against them, 20 companies that were using these kinds of plugins. Yeah,
they promise no risk of litigation, no risk of lawsuits if you have this plugin installed. It's a magic one fix thing that will stop any lawsuits. Not true. It's what it really is a stopgap. So if you know, if you realize that your website's inaccessible, you could install one of these plugins as a temporary solution in the meantime while you actually get your website fully WCAG conformant, and then you can get rid of the plugin. So it's sort of a temporary solution, just a quick band-aid on it, but it doesn't actually heal the wound, so to speak.
Awesome. So we'll move on to our questions. So we've got a few questions in the Q&A. So I will go through them. We'll answer them live as we go. So from Robin, how long does the process take? So I'm assuming that's the complaints process.
It can take a while. I suppose I'm just talking about the formal process. You put your complaint in, the commission's got to look and decide whether it's they think it's something worth investigating, whether they think it goes under the Act. Then they send it to the other side. The other side's got to respond. If we're talking about a big company, they're going to get their lawyers to respond, so they're going to take a while. I mean, and you want a proper, you know, if they're going to give you a proper response, you want them to take time. But again, you're not able to use the product while you're waiting. Then if you have a conciliation, that can take some time. Then there can be further negotiations. Then if that doesn't all resolve, then you're looking at a court process, which can take years. So it's not a quick process by any means. And I suppose I should say as well, if you want to make a complaint to the Australian Human Rights Commission, it's got to be within 6 months of the date of discrimination. I mean, if the website's continuing to be accessible, that date will continue to have to occur. Every day you do it is a new date, but it's worth us being aware of that as well, that there is a time frame.
Yes, I know from Bruce's point of view, by the time it all went to court, the Olympic Games had been and gone, so, and he was still fighting for that.
Yeah, I think he was trying to get that eventual outcome. They did give him some remedy in the middle, but it wasn't the full remedy, and it certainly wouldn't have helped other people.
Is there any idea of how many complaints are ignored? Potentially no, I'm going to go with, because we just don't know how. I know that before any of these complaints, these landmark cases that we talked about, each individual went to those organisations and complained several times over. They didn't just go in once and say, hey, I can't shop online with your service. I can't access, you know, I can't use your payment gateway. They went in over and over again and made that complaint. So I'd say that there would be a high number of cases that were ignored up until the point where, sadly, where organisations had to act.
Yeah, I'd say there would be a high number of complaints that are ignored, but there's also complaints where the organisation comes back and says, oh yeah, we'll look into that. And they sort of leave the complainant hanging on, how long, okay, what's going on? Can you give me an update? And then they have to go back to the organization and ask again, have you fixed this issue? Because I'm still having problems. So yeah, there's those sorts of ignoring as well, where they say they're going to do something, but then they don't.
And that's definitely true. Sorry, Laura.
I was going to say, my experience with it, when you get, I definitely agree. If you get into a formal complaints process with the commission, most complaints aren't ignored, in my experience with big companies particularly, because they know the reputational risk of that. But certainly smaller companies do, and individuals, they just can, well, what are you going to do? What are you,
It's in the backlog. It's always in the backlog.
Yeah.
From Catherine, I see the Human Rights Commission makes determinations as to costs. That question just disappeared off my. Oh, there we go. Where does this occur?
That's not entirely true. They don't. The Human Rights Commission doesn't make any determination at all. They used to in the olden days. So Bruce Maguire's first complaint was actually under Herioch, the olden days, 20 years ago. But now they don't make a decision about, there's no costs involved. It's free to complain. There's no costs because they're not making a decision. They're just facilitating a process. If you go to court, that's a cost. There can be cost decisions made by the judges at that point.
So from Ajit, I was curious as to how this is all handled in an internal sense, if and when digital accessibility standards are not met. If that's internal to your organisation, I've worked in quite a few private companies and also in the government, and there's a lot of misconception around it and not a lot of knowledge. So while quite often there's the intention is right, people just don't know how to fix things. So Matt, you got more answers for that one?
Yeah, a lot of it is, okay, internally you're trying to decide, all right, do we actually meet accessibility standards or not? And if you don't have the skill set in the team, then you're going to have to go external to actually get a confirmation on whether or not your website's accessible. But as far as the actual knowledge in organizations, either you have an accessibility team or you don't. And you need to have some training or something in place so that you can actually self-assess, so that you can go, oh yeah, we have self-assessed and we know that we have met WCAG. But even then, self-assessing isn't going to be as reliable as having a third party come in and take a look at your website and go, oh yeah, I can say without any bias that your website is WCAG conformant.
Great. From Melissa, do we assume that this applies to private sector? Is the process the same for public sector organisations and websites? Is that the complaints process? If so, yes, I believe that it is the same through government and through private.
Yep. So it's basically you've got to be discriminated against in an area of public life, and that covers government, that covers all sort of sectors. So it just needs to be a public provision of goods and services. There's some small exemptions, but most of the time, yep, that would cover that as well.
Excellent. From Karen, how well do you feel website and other application developers understand digital accessibility requirements? Many organisations rely on the advice of the providers assisting in the development of websites and other digital platforms. Matt, did you want to take this one?
Sure. It's kind of like a core problem as far as education as well. So example I always use is I did a Bachelor of IT a couple of years back, and I only had 3 marks of 1 assignment in the entire 3-year degree that related to web accessibility. And that was only because the lecturer for that course actually was disabled himself, and he was involved in the accessibility community, and he felt he had to put something in. That's the only sort of WCAG sort of knowledge I got from my education. So it's not exactly the fault of developers and designers to go into the industry and not have much clue around web accessibility, because they're just never taught it. Sometimes it's completely off their radar. They just don't know it even is a thing. But eventually, as they're in the workforce, they eventually come across this accessibility thing and they go, oh, what's that? And then they eventually look into it. Or their client says, hey, we got to make our website WCAG 2.0 conformant. Can you do that, developer? And the developer goes, yeah, all right, we'll look into that, sure. And then they might put some alt text on some images and they might just add a bunch of ARIA markup to the website and sort of overdo it with how much accessibility is in the website and ends up breaking the website even more. So yeah, the knowledge is unfortunately quite low. There are some developers who are absolute whizzes, and I really, really love it when I find a developer who is really interested in it and actually wants to do the right thing. They are definitely out there, but most developers unfortunately come across don't have much understanding and they need a fair bit of hand-holding as far as getting accessibility on their website. So yeah, a lot of organizations do rely on us Vision Australia or the original vendors to actually, all right, can you please make your thing accessible, because we're not sure how to do it ourselves or we're unable to do it ourselves. So yeah, people do their best, but it's really a knowledge thing. It's really just an awareness thing that we're still struggling with.
And related to that question, again from Karen, is are you able to suggest some good checklists or questions that organizations should discuss with developers that can test their understanding of accessibility?
There are some, as far as a checklist of questions that you actually want to test your developer. I don't have one off the top of my head. I might have to come back to you, Karen, on that one. Do you have any ideas, Charlie?
I guess I know I used to be a functional tester, and when people were employed, there is a functional test that you can do. So I guess having them produce some code and checking the accessibility, whether you've got the knowledge yourself to know if what they're giving you is accessible, if they're writing something in an accessible manner. So maybe getting them to produce some code for you to show what level of understanding they've got. I think a lot of the time, unfortunately, is that we rely on already built widgets and plugins and bits of code that are pulled from a code library. And if that code has any kind of WCAG or some kind of tag on it, people will assume that that piece of code from the library is accessible. So they'll plug it in without actually testing it or knowing. They'll just rely on the fact that here's an accessible solution for a drop down. Okay, cool, I'll put that in, but without actually having knowledge of testing and knowing whether what they're using is accessible, if it flows with the rest of the code that they're using as well. So yeah, I'd say live testing is probably your best, or showing a portfolio of work that they've done and looking at previous work that they've done, if that's compliant, if that website that they've built or product that they've made is accessible. Yeah,
you could, for example, if a digital agency claims that, oh yes, we can make WCAG 2.0 conformant websites, no worries. You could send one of their websites to us and we could have a quick look and see if we can find accessibility or WCAG failures on that website, and we can tell pretty quickly whether or not they're telling the truth or not. So it'll take us a 5-minute look just to take through a website and just say, oh yeah, there's one. And you can usually tell as well by if it's something really technical that takes a bit of digging to find, but if it's, some of the top 5 easy ones, then that not a lot of effort's been put in as far as making things accessible. So next question from Jane, is there any research around attitudes of organisations to make accessibility changes and the extent of what they understand their obligations are? For me, I've noticed there's definitely a cultural shift that, organisations are having, accessibility champions. They are starting their own hubs. They're starting their own committees. There's still a long way to go, but there's definitely more of an internal push up the line, depending on the experience of the people in that organisation. You get a lot of top down. If the CEO or somebody who works very high up in the company has any experience with accessibility or with disability themselves or with a family member, it becomes a priority in that organisation. But I don't know that there's any research about the attitudes, any sort of attitude shift. I've definitely noticed one myself though.
I'd say maybe look at the Human Rights Commission. They're doing some research. I noticed they're doing some research on digital changes generally, and they're sort of doing some consultation around that. So that might give you some suggestions about where I'm not sure entirely about if it's this particular topic, but it might be something that I know that the digital space is something they're looking at more generally as part of their overall sort of education and consultation work.
From Julie, how far off is stricter compliance legislation in Australia?
I'd say very far off. I think that's the problem. Like, I mean, this is the problem we see with disability discrimination generally. There isn't, it shouldn't be on the complainant to enforce standards and to fix these problems, but it is. And there doesn't seem to be any political appetite for changing that. It's always seen as, oh, it would cost too much, too hard, the hardship on poor innocent employers and companies and, you know, people providing things. We can't fix everything for everyone. So I'd say, unfortunately, I think we're pretty far off. I don't think there is much of an appetite for it, in my experience anyway.
There is a little bit of change coming through with the Digital Transformation Agency and the new procurement standards and things like that, but it's a very slow moving animal. And any changes that are coming through with legislation and government, there's also always the risk of a change in government or a change in minister for that particular department, where they could be totally on track for something and then they make a shift because the priority is different as well. Matt, have you got something to say on that one as well?
Yeah, the current legislation, as far as the standard that websites should meet, is WCAG 2.0 level AA, and that was released towards the end of 2008. So it's a 12-year-old guideline at the moment, and it is outdated in a lot of ways. 2 years ago, WCAG 2.1 came out, so it's an update, added some new things, and WCAG 2.2 is around the corner. So the world's moving forward as far as accessibility legislation, but Australia is still on this quite old standard. And yeah, there's no sign yet really of when the new recommendation is going to come through.
From Chrissia, what are the US standards called? ADA, how do they compare to WCAG? So the ADA is the American Disability Discrimination Act, I think, something that I don't have the actual acronym in front of me, but that's very much similar to our Disability Discrimination Act. There is also Section 508, which is the government standard. So that's for government websites, government procurement and things like that. WCAG are guidelines. They're the gold standard guidelines for making something, your digital assets accessible, websites and apps mostly. Whereas the Discrimination Act in America is very much about people with disability having equal access to things. So it ranges from everything, not just your online content.
Yeah, Section 508 is very similar to WCAG. Some slight differences, but very, very similar.
From Carly, how do you convince an organisation or employer without fully understanding WCAG? There is a digital accessibility issue. The standard response I receive is, we have checked it and can confirm it's WCAG compliant. That's one of my favourites, because quite often they'll run a tool over something and the tool doesn't pick anything up. So they say that their asset is compliant. And all you can really do is say it's not, and perhaps show them. Matt, you got further on that one?
Yeah, it can be hard when the organization's in denial and they say, oh, I've got this tool. It says 100% accessibility across our website. So there's no problems here. I don't know what you're talking about. Yeah, it can be problematic. So you got to, really roll up your sleeves and bring in someone with a disability and actually prove it. That's the only way you can do it, and send an official complaint, bring in Australian Human Rights Commission if you need to.
And that's one that I saw. I was working with an organisation and they had purchased a piece of software, and the vendor had stated that the software was accessible. And they said to me, can you just take a look and let us know? And it absolutely was not, in about 100 different ways. And we went back to, they went back to the vendor and said, it's, we had it checked by an independent third party and they said it's not accessible. And then they came back and said, well, we ran a tool over it and it says that it's accessible. So they came back to me and I said, well, no, it's still not accessible. So they went back to the vendor and the vendor said, well, look, here are the results from our tool. So there's really, it's a big problem with knowledge, and it really is about getting that independent third party, and that's whether you get someone to do the looking for you, or also getting training and building up your own knowledge, so that you know what you're purchasing from the vendor is accessible, or you know some things to look for that it's not. So next questions, and we are starting to get short on time again, as we always do with these sessions. But any questions we don't get through, and we've still got 25 more in the list at the moment, we will answer via email later as well, like we did the last time. So from Joanne, what are the three? What were key issues of the 3 Australian cases? What did they change, if anything?
Good question. I'm happy to have a quick go at it.
Yes.
The Bruce Maguire case, so that was basically when the Olympics and the ticketing came out. He's a Braille user and nothing was put in Braille. So he took them to court, the commission at that point, about that. They did agree to give a bit more accessibility, but as you say, by the time the Olympics started, then he also made a couple of other complaints. In terms of what it changed, it did, I suppose, make people more aware that things should be more accessible, and it gave some arguments, because it was heard as a full case, and it can be used as a precedent, so that's kind of helpful. In terms of the other 2 cases, the one against Coles was about the fact that the website was inaccessible, and every time they wouldn't update it, made it more inaccessible. Because it didn't go through to court, it doesn't change anything in terms of a broader precedent, but it does change things for Coles, because they agreed to fix whatever, like they made an out-of-court settlement basically to fix whatever they'd agreed to fix. So Coles should allegedly be more compliant now. And it's similar with the Commonwealth Bank. That was about the touchscreen, things that you can use in shops and also in the banks, and about the fact that they're not accessible. And again, that was something that was settled out of court, but the idea was that they should be given an accessible option with an audio plug-in so that people can use them effectively. So again, I suppose the point of those sort of cases is get a lot of media attention, get the company to then think, okay, I don't want to take this further. How can I fix this issue? So it's often not about taking it all the way through and getting a decision that you could use as a precedent. It's more about fixing this particular company and this particular issue, and hoping that other companies who have similar issues will look and go, oh, okay, don't want to do that. How can we fix ourselves in that way?
Absolutely. From Casimir, is WCAG considered good, or is it the bare minimum, and should we be aiming higher? WCAG is considered the gold standard. Now, I'm not one of our technical consultants here at Digital Access. I'm the least IT person you will ever meet in your life. And for me, making something WCAG compliant is excellent. It does mean that technically and mechanically somebody should be able to use a website, but it doesn't necessarily mean that the end user is going to have a good experience. So I always champion for user testing with people with disabilities to get their feedback, because just because you make something compliant doesn't necessarily mean it's usable, doesn't necessarily mean people will be able to use it or will want to use it. Matt, do you have anything further on that one?
I agree. You could go right up to WCAG 2.2 level AAA conformance on your website. You can be the best website out there as far as conformance, but there's something about your design that just makes it an absolute hellscape for screen reader users or people with disabilities to actually get through. And it's because WCAG is what you say is the bare minimum as far as accessibility. It gets people to a certain point, but it cannot possibly cover every single possible scenario on a website. It tries to do its best, but it can't do absolutely everything. So I absolutely agree with Charlie. If you want to actually make sure that your website is good, then you want to bring in people with disabilities, bring in the end user and observe them, give them some tasks to do on the website, see how well they can actually get through and complete those tasks. That's the only way you can know for sure if your website is actually accessible.
Excellent. I definitely agree with that. And we've got time for one last question because we are rapidly out of time here. From Robin, if an organisation has a policy for digital accessibility, such as Australian or state government digital standards, where do these stand in complaints processes or legal action? Laura, last one for you.
Look, it's relevant in terms of if they're trying to do something, but it's not determinative in terms of if the issue is that still, as a person with a disability, you can't access things. The policy's all well and good, but if it's not actually been implemented, or if it's not actually affecting your experience, so you're still not able to meet terms or conditions, i.e. if I want to use something on the website, if someone else without a vision impairment can do that and I can't, it doesn't really matter what their policy says. I mean, I suppose one of their defences could be our policy states we're working towards by this date. So therefore at this date, we're not accessible, but we will be. If they conform to that, potentially that could be a relevant defence, but otherwise it's not a determinative, we've got a policy, therefore that's our full defence to any claim against us, because the reality is it's got to be accessible, it's got to be usable. And if it's not, that can found a case of discrimination.
No problems. Oh, and we just lost Matt. He just fell out of the meeting. Hopefully he can get back in. But we are going to have to wrap things up now. There is a question from Marianne asking if the presentation will be available online. And yes, it will. So once we have time to get the recording downloaded, we will upload it to our YouTube channel. So it will be available with captions and a transcript, assuming that the recording all goes well, dealing with technology as we are. So in closing, yes, there is a risk of litigation locally and from overseas. And this could become more and more prevalent. The cases won't go away while there's still money to be made, and especially in America. And if they find that they can litigate against international organisations, people overseas, then they will definitely do that, because that just makes their pool wider. In Australia, the onus is placed on the complainant and the process isn't easy. But as businesses and organisations, whether it's government, private or private enterprise, the responsibility should really fall on us. We should be removing barriers to people with disability to allow them access to all of our products and services, even if it's just to be socially conscious and get the warm fuzzies. On the flip side of this is that the Australian disability dollar accounts for approximately $54 million. So I'm sure that any organisation out there would rather have a piece of the $54 million pie than to be paying out $400,000 or $1 million or $100,000. So that's it for today. I have the links here. We will post them out in an email. So that's for links for the Disability Discrimination Act advisory notes, the DTA's Digital First policy, and the Convention on the Rights of People with Disabilities. There are a lot more links out there. There is a lot more information. Again, we have upcoming trainings. So those links, the training link will be posted out to you as well if anybody would like to learn more about this or upskill themselves in the area of digital accessibility. And if anyone would like to contact us for more information, we have our email, website and training addresses up there, and also the address for the Australian Centre for Disability Law. So thank you for everybody for attending today. I hope that you got something out of this. We still have a lot of questions that we haven't gotten through, so we will collate those and get them out to you by email, assuming that the recording all worked in this session, which I haven't actually checked and I always get a little bit nervous. We will be posting the recording as well. So thank you to Laura for joining us. We really appreciate your expertise and your advice today. And thank you for Matt as well for your input and sitting in today. I hope that everybody enjoyed this session, and we will give you an update of our next one that we are planning. We should be having another one in about a month on a whole new topic. So again, thank you all for attending, and we will send you out the updates once we have them. Bye, everybody.
See you, everyone.
Oh, and we are recording. I can see it now, so that makes me happy.
Thanks, everyone.
Thank you, everyone, for attending.
Thanks, Laura. Thanks, Matt.
Thank you so much, Laura. Really appreciate it.
No worries. Happy to do it.
Bye, everyone.